All right, let's get started here. Welcome everybody to this January 5th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters, and I'm going to do a disclaimer here first to get us started. So take notice and acknowledgement that this show and our documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. And you will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand and agree that, with all rights reserved, without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted legal fees, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons to communications between the parties. By reading or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Some of the past shows I've talked about some pretty good-sized bingos, and on some of the other past Tuesday calls, I realized that why we weren't having a remedy. And on that first Tuesday night call that we had, I revealed that. So I'm going to really pick up there as to why we're not having a remedy and having any consistent success. And the book that I'm using is the one I've been always talking about, is Gilbert Law Summaries, and it's the one entitled Trust, and it's by Edward C. Halbach, Jr., and is the one I have is a 2008 edition. Now, what I understand, there's a lot of internet different versions out there that you can order, and really what you're getting when you order some of those, if you're not paying attention, you're going to order an earlier version, say like 1992, and it will not follow with the book that I'm using. So if you order this book, and I suggest that everybody that's serious about this and wants to follow along on these calls, that you get the actual book. It's only like $30 or less, and get the 2008 version. Make sure you get the 2008 version, because if you get an earlier version, you're not going to be along the same path as what I'm going to be talking about, and you're going to be lost. So I'm going to turn to Gilbert's Law Summaries book, and I'm going to turn to those of you that have it on page, let's see, I want to go to page 131. And that is under section 459. It's under the B heading, Restraints on Alienation. So alienation is really lien. Nothing can be liened up. It's going to be restraints on liening. And it's talking about the spendthrift and related trust. So in number 1, it talks about the general at 459, but under number 2, the spendthrift trust at section 460 states that a spendthrift trust is one in which, by statute, or more often by virtue of terms of the trusts, the beneficiary is unable voluntarily or involuntarily to transfer his interest in the trust. In other words, he cannot sell or give away his right to future income or capital, and his creditors are unable to collect or attach such rights, and this type of trust is usually created to provide an interest for the beneficiary that will be secure against his own improvidence. So improvidence is really his own wrongdoings, his own mistakes. So you see this spendthrift trust. Now think of not spendthrift trust, think Declaration of Independence. Because in the Declaration of Independence, we were granted unalienable rights, rights that cannot be transferred. And it was set up against our own wrongdoings, our own improvidence. So our founding fathers did us a great service when they set this trust up, the Declaration of Independence, except only those that signed it are the ones who've accepted it. So now let's read this again with some emphasis on Declaration of Independence instead of Spendthrift Trust. So it says a Declaration of Independence is one in which, by statute, now we know this can't be by statute because really it was before the statutes and codes came along. It was before the United States formation in 1791. So it's pre-statutory. Or more often by virtue of the terms of the trust. And the terms of the trust or the indenture is really going to be the actual wording in the Declaration of Independence. So the beneficiary, we the people, is unable voluntarily or involuntarily to transfer his interest in the trust. In other words, he cannot sell it or give it away his rights to future income or capital, and his creditors are unable to collect or attach such rights. In this type of trust, the Declaration of Independence is usually created to provide an interest for the beneficiary that would be secure against his own improvidence or his own wrongdoing. So that's really an estoppel created by res judicata, and we want to see Section 478 for those that have the book and continue on with that. But it gives an example then down below. It says the language, quote, settler to trustee in trust for beneficiary, to be paid to the beneficiary personally and to no other, whether claiming by beneficiary's authority or otherwise, quote, unquote, creates a spendthrift trust. So there's your verbiage, similar to that. So now, this Declaration of Independence is really acting as a spendthrift trust for the own protection of the beneficiaries, we the people. In case they do anything wrong, their assets are still protected, and they can't transfer them, nor can anybody else seize them. How wonderful that was in the beginning. So now I'm going to turn to, further in the book, skip a couple pages ahead to page 139, under Protective Trust, section 498. And under Protective Trust, it says a protective trust has long been used in England and is increasingly used in American jurisdictions. A protective trust usually is an ordinary trust that pays out its income regularly, but which upon an attempted voluntary or an involuntary alienation of the beneficiary's interest becomes a discretionary trust. Bingo. Sometimes a broad one to apply the income for the benefit of any or all of the group, that would be we the people, whether individually or as a group. That includes the original beneficiary. So now, in 1933, the people voluntarily gave up their gold and put it in special deposit into a trust deposit, and they set a trust up which they weren't aware of. Because under Gilbert's Law Summaries, again, on page 19 under section 67, and also under section 23, the restatement of the seconds in the law on trust, it basically says that no party in the trust need to know or understand they are forming a trust. Now that's the grantor, that's the trustee, or the beneficiaries. And it does not negate the trust from forming. So as long as you've got the elements necessary to form a trust, and one of the methods of formation of a trust that the law will recognize to be a trust, then the law will recognize it as a trust. And what you did in 1933, without anybody knowing, was that you deposited your gold into this trust, forming a trust, and the trustee was the United States. But the purpose for the trust was by the Founding Fathers, and the people in 1933 was a continuation of the will of the Fathers that set up the protection for the beneficiary so that the creditors could not gain access to the trust funds for the beneficiary. Because the beneficiaries, we the people, who was being represented by the United States, went bankrupt. And the creditors wanted their assets, and they tried to come at their assets. And this was a way of forming a protection against the assets being seized. So now it says that a protected trust was formed, and then when any attempted voluntary or involuntary lien against the beneficiary's interest, now this protective trust becomes a discretionary trust. Now I'm going to jump to the discretionary trust, section 490, on page 138. A discretionary trust is one in which the trustee, that would be the U.S. bankruptcy trustee, say that we all say we know as being Geithner or Snow or Paulson, or any successor thereof, or assignee. This trustee is given discretion the trustee is given discretion to make or apply or withhold distributions of income or principal or both to or for one or more beneficiaries, we the people, whether or not the instrument, Declaration of Independence, provides standards for the trustee's guidance. Now, this discretionary trust is under a more modern view, because I think it's being construed that they're saying that the 1776 Founding Fathers said that they had no alienability, period. And they're just continuing on with that. So now, the reason why we do not get a remedy today is because it's per the discretion of the trustee, the bankruptcy trustee. And we've always wondered why we don't have a consistent rate of success. Well, some things go through and some things don't go through. And I don't care what methodology you use, whether it's 1099 OID or whether it's redemption or whether you're using litigation method or whatever method that you claim you're using, nobody has a consistent pattern of success, and it's less than 10%. And I'm saying that what they're doing is really they're misleading you on a debtor-creditor path and pursuing that path when all along you should be going along in the other direction, which is 180 degrees from where you're going, and you should be going in the path of trust, because we're talking all about trust here. Everything is a trust. In 1933, when they took the legal ability to make a payment out, you can no longer complete a contract. You can't give value for consideration. You can't complete a contract. So we really don't have any contracts because we can't complete them. So something had to take and fill that void, and that void was filled by a trust. And everything is into the future, whether or not we get lawful money back to be able to complete the transactions. But now we have these colorable contracts, so to speak, wrapping and hiding the core, and at the core is a trust. But the big thing is about the trust that under no money, no parties in the trust need to know or understand they're forming a trust, but yet that doesn't negate that a trust is formed, like I stated earlier. So I'm going to go back to Section 490 again, but I'm going to turn the page on page 140. And remember, we were talking about protective trust instead of the discretionary trust. Back to the protective trust. It gives an example there that the settlor to the trustee entrusts to pay income to the child for life. But if the child ever becomes insolvent, in other words, if you look up in Black's Law definition of insolvency, it says that even though you have the assets, if you stop paying your debts, you are insolvent or bankrupt. So even if the child ever becomes insolvent, or creditors attempt to reach his interest in the trust, or if the child attempts to assign his interest, then to pay such amounts as trustee deems appropriate to or for the benefit of the child. And now jumping down to A, the rationale. A protective trust may be intended to reach a result somewhat comparable to, and in fact more secure than, the result of a spendthrift trust that we talked about earlier. But it is logically less objectionable. That's the reasons why they did all this, to make it look like it's less objectionable. Less objectionable in that the beneficiary can be sure of receiving substantial trust benefits. There you go. That's the reason why. He can be sure of receiving substantial trust benefits only as long as he keeps his debts paid. Now remember, he's talking about the beneficiaries here, we the people. So in other words, on the other hand, these trusts are subject to the criticism that they accomplish indirectly that which would not be directly in some states. And the Bankruptcy Code, 11 U.S.C., Section 541C1B, no longer accepts the intended result of a protective trust. So now it's a discretionary trust. So this is the purpose why. And the thing that's really holding us back, now that we've identified what the problem is, the logjam, and the effects of that logjam, that we can't get a remedy, now we can come up with a solution. And the solution is, as long as you keep your debts paid, then there is no discretion for the trustee to withhold. As long as you pay your debts, there is no reason for the trustee to use his discretion and withhold. He can make the payments. So, if we are good creditors, we will want to pay the original war debt of 1776, and that way the trustee will not have discretion to withhold. And we also want to pay the current portion of any public debts that we have incurred through the straw man, so that there are no past nor present, and we better make sure that there are no future debts. And then when there are no debts, you are now solvent, and then the trust fund is no need for the trust fund. The trust will terminate automatically because there's no purpose for the trust. No purpose for the trust. The trust will terminate automatically. And then the trustee should make the distribution of the funds to the beneficiary, we the people. Now remember, all this is not under what you think, debtor-creditor law. This is all under trust law, which is totally something different, because none of you have any concept of trust law whatsoever unless you studied it. Unless you've read this restatement of seconds to some degree and studied trust. Now remember, this Gilbert's Law Summaries, this is all a statutory trust. This is all the black. This is a statutory trust created under statutes and codes. It's all black. But if I teach you what the black is, as soon as you see white, you will recognize it by sight. And what I'm really talking about is a private trust, not a statutory trust. And a private trust is really the master trust, the Declaration of Independence. That is the one and only master trust which could be, say, drawn against my Bible, for instance. But the Declaration of Independence is something that everybody should know about in this country, in America. And all other trusts drawn off of that, say the Constitution, Articles of Confederation, all that, are actually sub-trusts. Sub-trusts like the Cesta K Social Security number, sub-trusts like the Foreign Situs Trust, which is really a spillover trust because at 18 it spilled over. You were supposed to take over it, and it spilled over into the Cesta K Strawman Social Security number account. And since you didn't express it to be a trust, it is construed to be under public debt because you didn't express the original 1776 trust. And if you don't express it, that allows them to construe it. So under Section 475, going back a couple pages on page 134, it says the creditor's rights and actions. So if there is a valid spendthrift trust provision in effect, creditors are generally barred from reaching, that is, attaching, and selling or taking the beneficiary's interest in the trust. And here's a case to support that, Commonwealth versus Burfield, 51A 2nd 523, and that's a Pennsylvania case, 1947. So thus it is said that the creditor cannot, just as an assignee cannot, anticipate the beneficiary's rights. So they're just anticipating, waiting for you to get credit for assets so they can jump on you to seize your assets. So all along, the Founding Fathers and the United States trustee is really protecting your assets against the liability that you've incurred with the creditors, because you didn't understand what you were doing, and you entered in all these debtor-creditor contracts, or that are really colorable contracts, but it was really trust. And you think you're doing debtor-creditor, or you're making a payment when you go to the grocery store and buy your groceries, or when you go to the gas station and fill up your tank full of gas, and you think you pay the gas station attendant. But all along, you were really forming a trust, and you never knew it. So you're doing trust every day and don't even know it. And we need to think more clearly about the relationships that we are forming on a moment-by-moment basis, whether or not we are forming a fiduciary or an agency or a debtor-creditor relationship or others compared to and versus a trust. Because all these other than trust look similar to trust, but yet lack one or more of the elements necessary to form a trust. And they're very easily seem to look all the same, but they're not. And we must know the difference. And we must know the difference on how to create a trust, because if trust is being created, we need to identify how it's being created and what its purpose is. Because is it your intent and purpose, or should it be construed to be under debtor-creditor for their intent and purpose? Only because you never expressed it to be a trust to begin with. Now, if it goes on later on, like in a mortgage situation, where you're foreclosed upon your insurance contract that the bank had you sign, or the unconscionable contract that made you a debtor for the 30 years, only because at the closing at escrow, you didn't express the trust and give the instructions by indenture to the trustee so he could do his duty and zero the account. But they said, okay, since you didn't do that, we want this insurance policy, we want this UCC1 filing and this financing statement and in the security agreement that makes you liable for us to collect money from you. You make payments to us because you're not paying the note at closing. Now, once you've learned all this, now you know and you understand what's going on, and you can go back and you can correct it all. Under Restatement of Seconds, I believe it's Section 342, that says you have the right to modify or revoke the trust on a mistake because it wasn't my intent or my purpose as grantor, and everything's being misconstrued here, and I'm coming in as grantor, and I'm going to prove the trust that I am the grantor, and I have the ability to do anything. So he who claims trust must prove trust. So if you say there's a trust here, you better have the information or the evidence that can prove the trust, or else you won't be able to prove it, and it's going to time out, and they're still going to construe you under debtor creditor. So now, here's where we need to put our thinking caps on and understand better the relationship between private and public. And I liken it to a ledger sheet, which is really nothing more than an upside-down T. If you took a T, a capital T, and inverted it upside down, you have the line coming down the middle and then the line across the bottom all along there. You formed an inverted T. That's an account in accounting. It's a ledger sheet. And on the right side of that, that's where the plus is. That's where the assets are. That's the private side. And on the left side of that is the minus side, the liability side. That is the debt side, and that is the public side. Now, both these accounts must match. You must be able to utilize both the public side and the private side. If you think you can get away from using the public side, you're far mistaken, and you'd better join another call. Because you must learn how to use the public debtor side through the straw man, or else you're not gaining access to anything whatsoever. Because all your assets that you're accustomed to using, all your fancy phones and your computers and every goods that and services that you're used to acquiring and consuming are all gained by the colorable titles through the public. Now, naturally, all the real material or real assets are held in the private, but the colorable titles to gain access to that can only be gained through the public side. Now, remember, by definition, a legal fiction says that it's a susticate trust or a constructive trust. So if we look under trusts in Black's Law 8th edition, constructive trust under trusts, it says constructive trust is an equitable remedy that a court imposes against one who has obtained property by wrongdoing. A constructive trust imposes to prevent unjust enrichment, creates no fiduciary relationship. Despite its name, it is not a trust at all. It says compare resulting trust, and it's also termed implied trust or involuntary trust. And down a little farther it says, quote, a constructive trust is the formula, in other words, the remedy, through which the conscience of equity finds expression. And when property has been acquired in such a circumstance that the holder of the legal title may not in good conscience retain the beneficial interest, equity converts him into a trustee. They're doing exactly that. But you see, the purpose of a trust, when it was formed way back whenever the first trust came into existence, the purpose for the trust was to take the assets that is being held wrongly in someone else's hand and put it back into the rightful owner's hand. And once that is done, the purpose of the trust ceases and terminates. And that is what the court uses to get the titles back into the rightful owners or protect it. And prior to 33, we had perfect title, we had a allodial title, and when we lost the ability to make the payments, the trust came in and solved that problem because we couldn't complete the contracts. But at the same time, it split the titles, split the perfect titles. And now, from now on, we can no longer have a perfect title or an allodial title because the titles are held in trust, which splits the titles. And now the legal title is held in the trustee, and the beneficial title or the real right to the property is held in the beneficiary. And any time one of the entities both holds the legal title and the beneficial title, the trust terminates upon a merger of the titles. That can be used to our advantage. So, definition of legal fiction. Legal fiction. Again in Black's Law, 8th edition. Okay, it says legal fiction. I'm going to jump down into the definition a little bit. It says a constructive trust is an example of a legal fiction. Constructive trust is a definition of a legal fiction. So now it says, quote, a legal fiction is the mask that progress must wear to pass the faithful but bleary-eyed watchers of our ancient legal treasures. But though legal fictions are useful in thus mitigating or absorbing the shock of innovation, they work havoc in the form of intellectual confusion. So these trusts, these legal fictions, are wreaking havoc with your intellect. And it is a shock for you on this innovation. That's what you're being. You're being novated. And this is the fact. This is the legal fiction or the mask that is really the straw man that you must wear to progress, to pass the bleary-eyed watchers of our ancient legal treasures. The trustees on the unalienable rights are our ancient legal treasures. So these legal fictions are what you're going to be using to gain access to the real substance held in the private, but you got to gain it through the straw man. You got to learn how to use this straw man as your puppet, and that puppet is a trust. And here we are, everybody's talking about trust, but nobody is following the trust path except me, and that's what I'm teaching. I'm teaching you how to live a trust, not just for asset protection as a private trust. I'm teaching you how to live and gain access to the whole trust fund setup and the ability to issue unlimited credits based on your signature held in the private. And I'm going to show you how to do that. We are going to bring the Republic back because once this is done, there is no reason for the trust to exist. And once the trust has no reason to exist, it terminates, and upon termination, that's when the Republic comes back. So, we must learn how to distinguish between private and public. We all want to take in the private what we know, and we want to haul it into the public and argue in their courts. And we want to tell them, I'm not that stinking fiction. I'm not that straw man. Well, I agree with you, you're not, but I'm afraid that you're going to have to learn how to live with it because he's your best friend. And when we tell them over there in their realm, in the public, which operates totally different in a mere form, backwards, than what we're accustomed to in the private, you're trying to tell them in their realm, dancing on their stage to their tune, that they're not doing it right. And they're sitting there taking all your assets from you, and if you want to hide like a squirrel up in a tree, you go right ahead, thinking you're searching for some nuts. Because they're going to look at you and they're going to say, okay, so-and-so up there, we recognize you. Oh, but I'm nothing but a squirrel. Yeah, right. You got a Social Security card, you got a driver's license, you got all these other adhesion contracts that you voluntarily signed, and you're telling us you're a squirrel? You must be incompetent. Send that man for a psych evaluation. In the meantime, take everything he's got. Take his car in foreclosure. Take his house in foreclosure. Try and stop that, being a squirrel. So we must learn how to operate in the public through the straw man. We can't go into the public realm with our private ideas and expect them to conform to our private venue when they're not even in our venue. You came into their venue. They didn't come into your venue. If you think you can get a remedy with that, you need a psych evaluation. So when we understand that on the private side, we are the grantors and we are the beneficiary. But when we come in on the public side, they want to see us as the trustees instead of the beneficiaries. And we sit there and we argue with them that we don't want to be trustees. We're the beneficiaries over here like we are in the private. No, that ain't going to fly. Because the 1040 form was the form that you filled out that was a declaration, which is a form of a trust, one of the methods of formation of a trust, that you swore to it that you were the trustee. And you are the trustee on that IRS record. And in that individual master file, that stated so. You are the trustee on that account. And you're the liable one for that account, and you haven't made the payment. But you're sitting there arguing, well, I've issued all my bills of exchange, my private money orders, but you guys won't honor them. But you see, it's still under the discretion of the trustee, master trustee of the bankruptcy, that he won't allow your set-off bills of exchange or money orders because you still owe the original war debt, and you still owe debts in the public because you're insolvent as we the people, and the administrator of we the people's bankruptcy is the United States. So don't go blaming them because you're the doer of all this mess by your signature, because you didn't know or understand that a trust was being formed. You didn't express the trust to begin with, and through the expression of the trust, by not expressing the trust, you dropped the ball, which allowed them to pick it up because they had to. They had to do something with it, and they construed it under what they knew best to do to protect the assets, and now you're the debtor under debtor-creditor contract until you clear up the debt and express it as being a trust again. And you got the ability to do that because you created the whole mess. You're the source of the power. Just like Dorothy, when she went into the Wizard of Oz, the first thing that happened was the Good Witch granted her on a trust the slippers, which represented the power to do everything in there. But she had to go through everything and through the movie till the end before she finally found out through the Good Witch told her, hey, you had that power to get home all along. All you had to do is click your heel together under rights, titles, and interest 3 times. And rights, titles, and interest, if you look up under Black's Law, under trust, right, title, and interest is talking about a trust. So that movie was expressing that it was a trust all along. And they were telling you, and nobody could see it. You had the power all along, just like we have right now. You're the one that created the whole mess, and we're the only ones who can go back and straighten it up. And we need to do it in their realm, the public realm, because that's the way it works, folks. You can argue all you want and cause a court case to take it to its fruition and a foreclosure, and you're down the tubes. Or you come in agreement with them. Agree with them that you are the trustee on this case. As much as it sounds like you don't want to be, that's exactly where you want to be. Because now the trustee you're going to say is liable for making the payment. I'll agree with you there. You didn't make the payment. But here's the big punchline. Here's the bingo. Under a protective trust, under a discretionary trust, since the beneficiaries are in bankruptcy, the trustee does not have to pay. He can withhold legally. Your defense under trustee is to not to argue. Agree with them. And what happens when you agree with them in court? There is no case. There is no controversy. The court case vanishes. Now, you're going to bring your private substantive evidence, your CCI, your trade secret, your trust information in private chambers on the private side of the court. In judges' chambers, you're going to call an in-chamber, in-camera hearing to review the evidence that you are the grantor and trustee on this case. But the reason, Your Honor, in chambers that I can tell you, because it's protected, I can tell you this in chambers, but I can't tell you this in open court. The reason why I didn't make the payment under trust law was because you, as beneficiaries, are bankrupt. And if I issue a payment to you, the creditors will get the assets and defeat the purpose of the trust, which I cannot allow to happen, Your Honor. So when I'll tell you what I'm going to do, Your Honor. I will issue some private credit, and you can do a set-off and free up the beneficiaries for being in debt and insolvent. And then you can satisfy the private side of the case as well as the public side of the case. And you can close this case down permanently. And I fulfilled my duty as a good trustee by issuing the payment, and there is no reason, because now the debtors are not the beneficiary. They are solvent, and they are creditors. And you do not gain creditor standing by being secured party creditor under debtor-creditor law. You become the grantor, and you gain creditor standing through trust. Your remedy is not in debtor-creditor relationship as secured party creditor. The remedy is in trust. It's commerce through trust and equity. It runs backwards, ladies and gentlemen. It's the mirror image. It's the effect of the Oz on Kansas. And we still have our stinking thinking stuck in Kansas. And we need to think like the people in Oz. And when you do, you will get your remedy. You will get your court cases closed. You will get all your foreclosures satisfied. You will get your issuances and your private credit granted. And to top it all off, when we go back and get rid of the past war debt and all the present debts, the master trust holding everything terminates, and when that happens, the republic comes back. Welcome to Money, Banking, and Trusts by Moving Titles and Commerce. I'm your host, Christian Walters. Let this be heard around the world. We are on a wave here, on a quantum leap of technology. NTT has new trust technology. It's not something that's new. Trusts have been around for a long time. But how we're using trust is revolutionary. Join that wave. Learn how to know and understand that no party in the trust needs to know or understand they are forming a trust, and use that to your advantage. Because that's how they apothecated you and got you back into slavery without you even knowing that you're a slave. And the best kind of slaves to have are the slaves that do not know they're slaves. And we do that so we can claim the trust and prove the trust, and knowing how to create evidence so that we have the elements of intent, purpose, parties, and specific res, and along with one of the four methods of formation under declaration, 1 or 2 by transfer, or 3 by appointment, or 4 by contract. As long as we have one of those methods of formation, and number 2 goes down into a sub 4, and those sub 4 are A, endorsement, B, delivery and bearer form, and C, assignment, and that assignment's on UCC 3, and D, by operational law, and that can be by notary presentment, notary dishonor. So there is your elements necessary to form the trust and the methods of formation of the trust, and as long as you've got those, you can prove the trust if you have the records created to do so. And once you prove the trust, the big thing about the trust is that you're in a court of equity. And when the beneficiary, who is the only one who can make a claim, proves, or it could be the trustee, he can make a claim also in certain cases. When he proves that there's been something done, then the burden of proof shifts to the other party. And the other party is presumed to be guilty. And the only way they can get out of it is if they have a record of a payment. So, that presentation there. So I think what we'll do is we'll open up for the questions and answers.
Conversation mode is on. Everyone can now be heard. Q&A mode is on. Participants may now unmute themselves.
Okay, so it's press star 6 to unmute, and let's go one at a time. State your name and where you're from.
Hello?
Yes, who's this?
Hi, Kristen. This is Cynthia in Chicago.
Hi.
I have a quick question. I'm reading the Gilberts, going through them page by page. One of the things that I found, perhaps you can expound on, and I got a little confused. The trust property, I think it's page 2. The paragraph there goes into how the trustee has the legal title to trust property.
Correct.
And all of the rest could itself be an equitable interest assigned to the trust.
Correct.
And then it goes into saying that in that case, the trustee would end up holding the equitable title.
Mm-hmm.
That part confused me in the regard that what you mentioned about having the equitable and legal title.
Well, the equitable title that they're referencing there is really the legal title. Because what they've done is since 1938, since the Erie-Clearfield, Erie versus Tompkins Railroad case,
mm-hmm.
where the law form has been changed in the courts, and they've gone to what they call a summary judgment system, And what they've done is they've redefined the definition of equity. So the definition of equity has been changed because in pre-1933, equity was what is fair and just. And now equity today is statutes and codes.
Ah, okay. And so this legal title in this particular paragraph is actually saying the legal title, but equity according to the statutes and codes.
Yes, right. Because this Black's Law is nothing but a statutory trust definitions. But this is all black, and what I'm really talking about is white.
Mm-hmm.
But if I teach you all about the black, you will know white by sight. And what we're really talking about is a private trust, not under statutes and codes, because it's pre-1791 United States. It's 1776 law venue. And under the International Agreement on Trust in The Hague, I forget exactly what section it is. I think it's number 6, Article 6, which says that basically the grantor has the ability to set the law form. And that's probably in the restatements on trust also.
Yeah, I read that. I read that as well, that the grantor does have that position. But you mentioned about having the position to revoke the trust by because of a mistake. But you said the time could run out. I didn't see anything where it mentioned a time frame for that being able to revoke it.
I don't think I mentioned a time frame because really there is no time limit.
Yeah, that's the impression that I got. But you mentioned something about letting the time run out on it.
Well, that may have been construed to be say there was a time limit, but really there's no time limit to go back and correct anything.
And so I'm being able to go back and correct some things, especially in particular to the trust that was created, for instance, with a mortgage.
Yes. That section, I believe, is, I think I might have quoted the wrong section. Now I'm looking at it.
Would the promissory note on the mortgage be considered the trust property, or is that's just the...
Well, it can be trust property, yes, and also the case itself is trust property, because I'm going to turn the case itself into trust property.
Oh, yeah, the case itself, yeah, because it has to be distributed over, but I guess the thing...
All proceeds from that special deposit.
Exactly.
All bonds attached to that case are mine also.
Exactly. And so the OID, looking at the OID differently now, not much different, but with a clearer picture. But it seems as though that we shouldn't be in position to claim an OID if we hadn't.
No, if you do OID methodology, you're probably going to connect yourself back with an effective U.S. business or trade.
Wow.
But there's a workaround with that. Everybody needs to start thinking outside the box. They need to start exercising their minds because that's what they lack. Because there is a safe path through the minefield of the IRS forms.
Okay.
Path. And we're going to use a W-8 BEN and a W-8 IMY, but not in its original form. I went over on one of the shows. It's the instructions of the requester of forms W-8 BEN series, and in there that talks about a substitute form that can be used. And that's the form we want to use because we're cutting all the other garbage in that standard form that you get from the IRS, cutting all that out that ropes you back up into the system.
Yeah, I actually saw a W-8 form from years ago. It didn't have the BEN on it. It didn't have anything. It was just a simple W-8 form. And I tried my best, but I couldn't find when exactly a change took place.
Right. From
being just a W-8 over to all of the other different...
well, the IRS really says that you don't need to use their form. You just need to use the substance that they need to see. And it says on the instructions there that really the purpose of the W-8 series forms is just to establish your status. And they say right in there that you don't have to consent to anything on this form. So I can cut stuff out that I don't consent to.
And I'm thinking that's exactly what I saw.
Yeah.
Back then, I didn't, of course, realize it.
Yep. So I want to make a correction on something I said earlier. I thought that was Section 342 that gives you the right to modify. No, it's Section 32. Under Section 32, the law on trust states that a reservation of power to revoke or modify. That's where that's at. And there's no time limit to that. Because it was by mistake.
Yeah, but you even though it's by mistake, and I'm just looking at the what that actually entails. Because if you go back and revoke that through the mistake, and you're actually going to be laying claim to all of the trust property or income that was garnished from that.
Well, don't revoke the trust. Modify it. Do the correction on it.
Oh, I see. Okay.
Unless it
Reestablishing the
serves
position.
my purpose to revoke the trust, if it's a court case or foreclosure or whatever, yeah, it might serve my purpose maybe to revoke the trust and modify it. But if I can just modify it and get the same results, that may be all I need to do that's going to sufficiently suit my purpose.
Okay, I see that. Thanks, Christian. Appreciate it.
I have a question in Atlanta, Georgia, in Wilson.
Yes, go ahead.
Yeah, you mentioned we have to pay the debt in order for the trust to vanish. Now, if we can't pay our debts in the public due to the bankruptcy, how will we exercise the process to solve that problem?
Well, you see, you can't gain access to the set-off, the ability to do the set-off because you're bankrupt. So you go and solve the bankruptcy problem first.
I see. Yeah.
Like what came first, chicken or the egg? Well, I can answer that. The chicken came first.
Right. And how do you solve the bankruptcy? Through the trust process, you say?
Yes, through trust, yeah. In the example I gave, when I want to come into this court case and be the trustee on this, because when I am the trustee, I'm going to claim the reason why, which is legal, why I didn't make the payment was because you guys are bankrupt. But here's my set-off, the solution to the problem.
Right.
I'm going to use my private credit to make you solvent again. Which now you don't have discretion to withhold, and you can release the funds simultaneously with the set-off.
Do we issue this through some kind of a note or a promise pay document?
Any non-negotiable debt instrument, not negotiable, non-negotiable debt instruments are private. If you don't have non-negotiable on your instruments, they're all public debt instruments.
Right.
They're on the public debt side.
Yeah, I think all of us have been using that statement, private between the parties, non-negotiable, et cetera, et cetera. Yeah,
well, you can take an instrument that says non-negotiable on it. If you negotiate it in the public, you just turn it into a negotiable instrument.
So it doesn't go into the public; it stays in the private.
No. If you, by your actions, negotiated a non-negotiable instrument in the public, you are making it negotiable by your actions. And writing over by your actions what you stated your intent was by writing non-negotiable on the instrument. Because your actions are controlling, not your statements.
So how does it in the private, you throw a private administrative process and not go into the court situation, you say?
Yeah, you want to agree with them that you owe the debt, now there's no court case, and then provide the payment and the reason why you didn't pay on the private side.
So this can be done with a simple statement, basically an affidavit, I guess, with the statement that you have just made, and do just that, can't you?
Yeah, you could do that, or you could do it orally in chambers.
Right.
Also, Section 332 is power of revocation or modification omitted by mistake.
Right. So if you get a debt from a collector, let's say, for a credit card for $4,000 or $5,000, you can agree to pay it, and then give them your exemption.
Yes, but we're thinking too small. You're thinking about your immediate problems, all of you, which are the issues on the leaves of a tree. And if you pluck the leaves off, you get more leaves that come back.
Right.
Because you haven't pulled the tree out. I'm talking about pulling the tree out. Right. You don't have any more issue problems. No more leaves grow back. And all you're thinking about your little individual problems about your little mortgage foreclosure cases and your arrests and stuff. No, you need to be thinking about the main problem, which is you need to get back and take it all over.
Right.
Have another question?
Yeah, this is Keith in Cincinnati.
Yes, go ahead, Keith.
Yeah, hi. I received an email from you listing all the videos on this technology, or not the videos, the audios on this technology. I guess there's 30 plus. I just received the Law Summaries book on trust. You have, I guess, some clues on where to start on that Word document that you have.
Yes.
Any tips on digesting this information? It's I know enough about trust to be a little dangerous. I'm not totally ignorant on the subject, but I guess like any other subject, you want to conquer its language first and understand what each definition of each, word.
Right, because we're not using trust as a protective trust like everybody's using protective trust that are private trusts. We're using trust to live it. And in order to do that, we must understand all the little nuances and how it comes into existence so we can mimic it and prove it. And that comes with studying the basics, really.
Okay. Any other tips on studying this information or how to go about it or tackle it?
Start at page 1 in the book and read through the book. That's the basic foundational stuff, really. But keep in mind that you're studying statutory black, trusts.
Have you ever heard of a method of trading your own private trust and moving like everything off from the strawman trust over this other trust that you then control?
That's what I talked about on the 1221 call.
Okay. And what document would you use to satisfy this war debt? I guess going back from the Revolutionary War
debt instrument.
Okay.
Money order, bill of exchange. It could be, all I'm doing is authorizing them to take the money that's in the trust fund already and pay the original war debt. Nobody's ever done that.
Mm-hmm. Yeah, I've heard that the 1040 form come about during like World War II, and anybody that is still using the 1040 forms, you're still basically paying for that war.
Yeah, that's how they're using it to get the interest on the principal, but nobody's paid the principal. So if the principal's still $20 million, we've probably paid $100 trillion over or more, who knows the amount, in interest on that till to date. Now, that stinking $20 million principal is what's keeping us from being solvent, along with all the public debt that we've created on the public debt side. So all the bonds that we put in under the birth certificate, all we did was create more public debt, thinking that we were creating set-offs or offsets against that, and really we haven't. We've been just creating more debtors, bigger debtors, to pay debts with and double debt, and they've loved us for it. Because debt's what they're using as money in that public realm. And all along we were thinking we were doing a set-off, and we weren't getting into the private account at all, because if we would have, it would be commingling, because we're trying to cross one side into the other. Can't do that. Oil and water don't mix.
You mentioned about pulling a tree out from its roots. I mean, a little electric bill or phone bill, that's to me nothing. I mean, I think the biggest chunk of anybody's income that is taken is obviously federal taxes between FICA and Social Security and so forth. Over the tune of half your paycheck. I wonder anymore at what point does people get, what's it worth even going to work when they start taking 80-90% of what you work for? But I went the route of the W-8-BEN and reclaiming my status with the company I work for. I've sent in the forms to the IRS, Social Security Administration. Long story short, what ultimately happened is the IRS sent a computer-generated lock-in letter to the company I work for saying to take my status to single, 0 exemptions. The company I work for just basically rolled over the payroll department and did what the IRS said. Mm-hmm. Now, short of me going to war with the company I work for, it should be up to me to claim what taxpayer status I am. This didn't prove out to be successful. Like I said, the company I work for, it wasn't a court order. It was a computer-generated IRS letter, and that's been my status now as single with 0 exemptions since like 2007.
Did you use a standard form, or did you modify it and substitute it with something else?
I used a modified form. There's a site out there called EDM.org, Sovereignty Education Defense Ministry. They have just a ton of templates, and they go through that whole process of you're not doing trade or conducting business within a federal jurisdiction. They kind of have a modified W-8-BEN affidavit to send into the IRS and Social Security and to the company payroll that you work for. And none of the affidavits were ever rebutted or responded to. It's just, again, this lock-in letter went to the payroll department, and the company just, they rolled over.
Good.
So again, it's just disheartening when you can't even claim what taxpayer status you are, and you got people that you can have your pay taken before you even see it by nothing short of a court order. It's not even a court order. You get a computer generated letter from not even signed by anybody, and your pay is taken from you.
Right. We want to go back in and correct the whole individual master file in the IRS, and then once we've done that, then we can use the W-8-BENs and the IMYs more effectively, and we can issue private credit for making all kinds of payments.
So I just look at it as trying to go different routes of resolving the issue instead of trying to fight it on the front end. I'm going around, the 1099 process, go ahead and let them withhold and try to do it on the back end through either the 1099 process or other remedies. But trying to have the withholding stopped on the front end has just kind of proved out fruitless. Different attempts that I've done.
Yeah, you have to keep it colorable because that's what they say in court. I read transcripts and things of the judge basically telling the alleged defendant, straw man, hey, you're putting too much truth on a court, really, if you can read between the lines. And that's the really reason why they send you for a psych evaluation. That's a warning that you're putting too much truth in here.
Okay, thank you.
Okay, who's next? Who's got a question? Press.
I have a billion questions, so I won't ask one. This is Donna from Florida.
Hi, Donna.
And hey, how you doing?
Good.
I just wanted to tell you, I have such great respect for you. I've sent so many people to you, and you sit here night after night and you do this. I mean, I don't see that you get a whole bunch of donations or anything like that. And I think that's pretty sad because you truly are your brother's keeper. I mean, that's my opinion of you, and that's a very, very high opinion. So I wanted to ask you, how do we make a donation to you? Well,
we're on the realpublicradio.net on Saturdays, and Desert, he's the one that's really hurting more than I am. So, he's supporting that network. That's his network, and my show just happens to be on his network.
Okay, well,
where I'm going to derive my income from temporarily until we get this all straightened around is through the workshops. I've been saying I'm going to release the information on the workshops. I'm very close to it. I got some details to figure out with some emailings and mass stuff like that. Everything is pretty much set to go. How you're going to help me out is when you join the workshops, because the workshops are going to cost, you guys something. I'm going to charge for that. And that's how I'm going to make my living until we get everything all straightened around here.
Well, I can send Desert something, but I think we should do like a money bomb on you tonight.
Well, that's up to you, so.
Well, listen, I mean, I've sent a lot of people to you. There's probably a lot of them on the call right now. And, it's basically just a one-way street right now. It's been that way for like a year and a half. And you may be charging something in the future, but you're very rare. And so I think anybody who can possibly donate anything, please do. And to you, Christian, not to Desert. I mean, I can do something separate with Desert. But, whatever's donated tonight, I'll match it up to $250.
Okay, great.
Okay. And, you just do so much. And I mean, you're the only one I listen to anymore. I mean, because every freaking thing you say makes total sense. And every other system, I'm not trying to make anybody wrong or make anybody else look bad, but there's always been something or some things that just didn't fit, and this is the only thing that I've seen that really fits everything.
Well, I will say a lot for those guys because I learned a lot from those other people, like Sam Kennedy, Winston Shrout, Jack Smith, Gene Keating, Paul Capel. I learned from those people.
I learned too. I learned to always put void where prohibited by law or statute.
Yeah.
I'd probably be sent to prison right now. But I just wanted to tell you I really appreciate you very much, and please send me an amount tomorrow, and I'll donate it. Just let me know where to donate it to.
I'm working up addresses, post office boxes, and things, for that. PayPal and all this stuff. But that's coming in the near future. So
yeah, I'll help set you up a PayPal account. No problem.
I'm in the process of getting the web set up and all that good stuff.
Okay.
Main names and everything.
Fantastic.
Hey, Donna.
Hey, is this Dave?
No, this is Harold.
Oh, Harold! Oh, my gosh. How are you doing?
Okay, don't forget me. I need funding, too.
Oh, no problem, buddy. I love Harold. Harold is absolutely amazing. He's going to come see me one of these days. Aren't you, Harold?
Yes, so willing.
You better. But you guys have a fantastic night. I'm just wiped out. I'm going to bed, and really appreciate everything you guys do. Very much so.
Okay, appreciate it very much.
All right.
Hey, Christian, this is John in Phoenix. I'm one of those ones in a really bad court case, but what about Form 56 from the IRS? Have you used that? Do you have much faith in it?
Well, the only thing I would use Form 56 would be to appoint myself trustee. I know a lot of people don't,
Okay, so
but that's what I would use Form 56 for.
have you do you see any use to appoint like a prosecutor, public defender, or a judge as a fiduciary on
You're
basically high felony case?
right now, and I'm thinking trust. Because in a court case, I'm going to come in as trustee, establish the fact that I am trustee and the grantor, and now I'm the 900-pound gorilla, and then I'm going to, in chambers, declare why I didn't make the payment. And that's because a protective discretionary trust is in place. And, Your Honor, I can't make a payment until the beneficiaries are solvent. And when they get solvent, then I can make the payment. But in the meantime, to make them solvent, here's my payment. Now go ahead and settle this account. And, oh, by the way, you were right on the public side. Yes, I agree with everything in this case, and therefore there's no case. I admit that I owe. Just tell me how much it is I owe, and we'll go into chambers and we'll talk about this under a protective order. We'll do an in-camera hearing, and we'll settle up. And I'll tell you the reasons why I haven't been able to make a payment. And under the law, on a protective trust, I can't make a payment, Your Honor. And you know that, because now we're in equity in chambers, where trusts operate. And that puts them between a rock and a hard spot, and the judge got nothing to do but accept my set-off, or my instrument for set-off, and close that trust down. You see how it works?
Yeah, I'm weighing it against what one of the people that you mentioned a minute ago are saying, that I'm seeing what they're doing is failing miserably. And I'm leaning much more towards your side of it because of the issue. They are trying to pay for the court case, and they're trying to do it basically publicly in the court, and it seems to be getting some people put in prison rather quickly. So
because really, by putting it on the public side of the court, they've waived it. So this comports to Rule 501 of Federal Rules of Evidence, which basically says that the federal goes with whatever state you're located in, whatever their evidence rules are. So you got to really go to your state evidence rules. And then in my particular state, Florida here, it says that Rule 501 comports down to 90.501, which is the general rule, all the way down to 90.510. But I keep coming back to this, in particular, 90.506, which states that privilege with respect to trade secrets. So my trade secret information, my CCI, confidential commercial information, is really, when I bring it into the public, secret information that I'm making public. In 90.507, what happens is it says that there's a waiver of the privilege by voluntary disclosure. So by me disclosing it in open court on the public side, I've waived my private substantive rights to do a set-off. And I just lost. Now they won't honor the set-off. I should have done it in chambers where it would have been trade secret. And to keep a trade secret, I would put a protective order under discovery rules. And that would be my reason, because the reason why I need a protective order is because this is confidential. We don't want this stuff to get out in the public. This is trade secret information. And now the judge is in a hard spot, between a rock and a hard spot, and is going to have to do the set-off, or else he's going to be in breach of trust. And then that opens up all the other trust remedies and causes of action for unjust enrichment, conversion, fraudulent transfer, and then the big one, antitrust, because you're operating against my trust. You're impeding commerce, which is a monopoly, and that contains the criminal side of it. Criminal enforcement on that one. So I don't think the judge is really going to want to go there. You'll probably get your remedy. We're going to see a massive increase in the success once we get the paperwork set out. But we got to keep this.
Yeah, that does actually make a lot more sense. I've been a student of this for a long time, and I know Jack Smith and Winston and Sam personally, and have for a long time, and we've gone back and forth on some disagreements on some of this. I agree completely that pulling the private into the public always causes problems. I guess where I'm missing some concept of how the judge, being part of the public, has the authority to settle the issue privately and then without informing the public of how the issue was settled. In other words, he settles it in chambers. He has to go out and tell the public.
No, he doesn't.
But he has to do it with a lie.
Well, yeah, that's the way it works, because the fiction public side of the court is the lie.
So the lie is perfectly acceptable. It has no...
Colorable.
There's no recourse. Okay.
It's got to be a colorable remedy on that side.
Christian, can I ask about, you said they don't go through the clerk, so how would you do that then?
Not to go through the what?
You don't go through the clerk?
Oh, through the clerk? Yeah, I do a notary presentment directly into the judge. I put it in care of the court, but it's marked to Judge so-and-so in care of the court, in chambers.
In chambers. It's very important that you put in chambers on it.
And then you put on the documentations, not for filing, in big letters.
Not for public filing, correct.
Christian, would you mail that in?
Can we what?
Would you mail that in?
Notary presentment. I got a record created by the notary that he sent something. And the reason for that is because the notary certificate is outside the hearsay rule, in case I ever have to use it.
Yeah.
It's self-authenticating document.
That was the piece that was missing for me.
He's creating the record that I need to prove whatever I did. I don't do anything without a notary certificate to prove that I did something. Whether I'm filing a UCC-1 to the UCC or a 3 or even into the county. I just like that additional proof that I've done that, even if I pull out certified copies. You always want to get
I'd like to make a comment on that. Oh, sorry.
Yeah, go ahead.
Oh, please do.
Well, on the notary thing, I recently proved that I have a major case that I'm in the middle of. And having a notary, not just the notary presentment, but having the notary do everything to the court. In other words, not filing your own documents, not having an attorney file the documents, but stuff that has to go on the public side. Having the notary do it, the court's stuck with it. And I even verified this by talking to a sitting judge that's a friend of a friend for quite a while. If a notary not just mails it, not just as a presentment, but if the notary actually is the one that goes to the court and puts it into the case, there's nothing they can do with it. They've got to keep it. Judge can't deny it. Judge can't strike it, or he's in violation of his oath. Because a notary, under the concept from amicus, is a public officer, and nothing can prevent him from operating in the court, not even the judge.
Right.
And in some regards, they almost have more power than the judge in certain aspects.
Sorry, that could be very interesting for placing in a non-negotiable death instrument into the private.
Yeah, I might want to use a proto notary for something like that, though, too. A proto notary. Private notary.
You can also check with your state. Most states consider any military officer, not an enlisted, but any military officer, to have the same authority as a notary. So, and that can in most cases include a retired military officer, because they're never truly retired. They can do everything in court, and the judge is SOL. You can't fight it. Just thought I'd throw that in, because I actually got it to work.
Christian, did you say a proto notary?
Protho. Protho. Yeah, look and learn what that is in Black's. Look that up in Black's Law.
This is John in Atlanta. Back up a little bit on two things. One, on the section where you were talking about agreeing with court on the issue at hand. Something silly, kind of small, like a traffic ticket, running a stop sign or something like that.
Mm-hmm.
I guess seems to me counterintuitive that you would go in and agree to that, whether it's points on your license or insurance that goes up or
but
whatever.
If you confess that you owe that, you cancel the controversy, and the controversy is the case. So by doing that, you cancel the case. There is no case. So you settle one side of the account by confession that you're guilty, say, and you make the payment, and that settles the civil and the criminal side of both sides.
So are you saying that you're admitting the guilt, or you're just agreeing to pay the fine?
No, I admit to the facts that, that I owe the debt. I'm not confessing to the crime, because there really is no crime.
Well, I realize that, but in the statutory sense, how do you delineate between, yes, I owe the $100 for speeding, but I wasn't speeding?
Well, I'm going to plead guilty to the facts of the case, but not to the charge. And then change the plea, because if you confess before they deem you guilty or declare you guilty, then it doesn't count. It doesn't go on your record.
What do you mean it doesn't go on your record? If I walk into court in Georgia and I say I'm guilty of speeding 55 and a 35...
Yeah, but then you pay with Federal Reserve notes. You don't pay with your private side stuff.
Well, that's true in the traditional sense, yeah. Absolutely.
Put yourself back under statutes and codes, liable for the code violation, and everything else is deemed against the straw man.
Okay. All right. Second thing is you were mentioning some of the other people that you'd worked with, Winston and Gene and those type of guys. Of course, everybody has their own system and what documents they should file and that type of thing. What's your thought on a foundational document package of some type being filed to notice the system of what you're doing?
That's basically what we're going to start here with the workshops, yes.
Okay. Any idea when that may be available?
Well, I got an email problem. Every time I send some emails out, I got to get that straightened around. They're shutting me down on mailing out emails. So I got to get my own domain name, set up a website.
That could be fixed with a domain, yeah.
Yeah.
Definitely interested in some workshops when those become available.
Yeah, I have to be able to communicate with everybody, so when I notice everybody, they should shut me down. I exceeded my limit because they think I'm spamming, so.
Right. I can probably help you with that if you're interested in doing it, or if you need the help.
Well, I've looked at some web hosters, and I kind of picked one out that looks kind of good, so. But, yeah, if you have some expertise on that, send me an email at movingtitles@hushmail.com, and let me know what you...
Title, plural?
Yeah, moving titles, one word, plural.
Okay, at Hushmail. Okay.
Yeah, movingtitles@hushmail.com.
Will do it, sir. Thank you very much for your help.
Thank you.
Hey, Christian.
Hi, Rhonda.
How you doing?
Great. How about yourself?
Oh, shivering my timbers. It's chilly.
Ah, yeah.
That global warming is darn cold, I tell you.
You cut the head of that snake off yet?
That's what I was just going to say. About ready to fillet that baby. So theoretically, listening to what you said, I like what you said about the one fellow was talking about, going out in public. They lie, of course. And what you was reading earlier about the blurry-eyed watchers, the legal fiction.
Right.
That what you say is something about your mind, or it messes with your intellect.
Yes. It wreaks confusion.
Havoc.
Yeah, wreaks havoc, yeah.
With your intellect for the blurry-eyed watchers.
And then your innovation, which is really, they put in together with novation. Your innovation, but really you're being novated. There's a change being made, whether you like it or not.
Right. So theoretically, listen to what you said about being the trustee and about the trustee has the right to withhold payment if the beneficiary is deemed to be insolvent.
Under discretionary trust, right.
Under discretionary trust. So theoretically, if the IRS sends me a presentment for a bill that needs to be paid by the trustee because I confessed to being I declared to be a trustee on the 1040.
Mm-hmm.
Theoretically, I could write them back and say, great, I agree, I owe this. However, please send me evidence that you're solvent, and I'll be happy to pay it.
Well, why not do one better? Why don't you go ahead and pay it,
Okay. Yeah, I could do that. So on a non-negotiable...
Let's maybe one better yet. Let's straighten out the differences between the Social Security Trust, which says that you're the beneficiary, and now the 1040 form declaration trust that you declared that you were trustee. Let's go back and correct that one to match the Social Security beneficiary. And now you're not incompetent. Now they'll take the payment.
So, run that by me again?
Okay, see, there's a problem here. You're incompetent. And what makes you incompetent? Because your declaration trust on the 1040 form, where you declared yourself to be trustee without knowing it or understanding it, does not match. It's in conflict with your Social Security SESTA-K Social Security number account, which you're the beneficiary on, because you get the little card back that's a beneficiary card, the benefit. So you're
when I need to go back
beneficiary on one side of the trust in the Social Security account, but on the other side, the one that's the IRS one, they got you down as trustee because that's what you said you were.
So basically, I can just make another declaration because, I mean, if I can make a declaration I'm a trustee, did I hear you properly when you said that you have only a grantor can make a declaration?
Well, he's the one who establishes the trust for his intent and purpose, yes.
So you have to be a grantor to be able to make a declaration. So
change
if I was able to make
trust, yes.
So if I was able to make a declaration on the 1040 with my signature to declare myself as trustee, then I ought to be able to go back and make another declaration because there's already a trust proven there because I already made one declaration to go back and make another declaration to say I'm a beneficiary.
Right, and have the evidence that you are who you say you are.
Okay. Now, say you got a mortgage situation and you want to send a non-negotiable instrument. Would it be best to go to claim the title on possibly the instrument that you already wrote and move that title so it's so that both titles are in the beneficiary's hands to terminate the trust, or could you just go ahead and write out a non-negotiable instrument privately and send it to the trustee that they've already appointed and direct them to go ahead and adjust the account with your non-negotiable instrument?
All right, so I kind of lost you somewhere between the trustee that you're saying.
Okay.
If you're the trustee...
Would it be possible to send a non-negotiable instrument money order to pay for a mortgage?
All right, a mortgage payment. We're talking about a mortgage foreclosure then. Okay.
Yeah.
So we already made a negotiable debt instrument payment already. You're not talking about the original note. You're talking
right,
about
I'm saying
one?
Yeah, not the original note, but if if it was down to the wire, and could you just get evidence that you're the grantor, make a record of that, get your witnesses for that, and then just go ahead and make out a non-negotiable instrument for the payment? Could you do that and send it to the trustee and give him direction
I might be able to go back and instead of issuing a new negotiable instrument, I might be able to take the one that I did and say remodify the trust that it was done under a special deposit. And if it was done under a special deposit, then it was a trust deposit, which should not have been commingled, and that might work that way.
Okay. Now, getting back to the issue of only a grantor can make a declaration, we've talked about the Declaration of Independence. There's your trust language, declaration.
Yes.
Now, I've been thinking this through in my head, and okay, people come out here in the public, or they make declarations, they write declarations, and they send them to somebody and say, okay, I'm making this declaration. And the way I'm looking at it is these people they're sending it to is saying, well, that's fine and dandy, you're making a declaration, but where's the proof, where's the evidence you're the grantor to be making a declaration, right?
Could be, yeah, because you don't come in, you're making a claim that there is a trust because you're making a claim by declaration, but then you're not proving that you're the grantor on the trust, yeah. So it times out in 30 days, say.
You don't have no evidence that you're the grantor.
Right, you didn't prove the trust.
So the Declaration of Independence.
Trust.
Right, the Declaration of Independence.
And that kind of explains why they wait about 30 days, and then all of a sudden something happens that you don't like.
What was that?
That explains why usually in about 30 days they wait. And then usually after 30 days something happens that we don't like. It's like we make a payment, and then all of a sudden everything shuts down, and it waits for like 30 days or a little more, and all of a sudden something comes down that, we don't like. They don't honor the payment, or we get arrested or something, Because we didn't come in with the evidence to support our claim. We had an NOI that we're the trust, we're the grantor, we're the beneficiary or the trustee or whatever, but then we didn't follow it with the SOI, the statement of interest, which is the material fact to prove our claim. We don't have any evidence or records to prove that. Right. And that NOI, that claim, times out.
Okay, now, on the Declaration of Independence, did there have to be, what's what's our evidence if we're keeping in mind that there had to be a grantor to make that declaration of independence?
Well, that grantor is God.
Okay. Okay,
God,
so you don't...
Grantor, and he's the trustee on it, and we're the beneficiaries of that Declaration of Independence.
So that was just a qualification of what had already been given to us.
Yes.
An acceptance.
Right.
And like
Nobody's
you said,
there was 56 signers on that thing.
And we want to become a signer on that thing.
Yeah, we can do that by an acceptance of, say, putting our signatures on the allonge on an acceptance and attaching that allonge to a certified copy of the Declaration of Independence. And then go get that apostille and put it in the International Hague Convention, since we're foreign to the United States, and then notify all parties. Due process.
So that's going to be our first step in getting ready to cut the head off the snake.
Yes, I would suggest everybody who wants to participate in this, they get 2 copies of, say, the Declaration of Independence from the National Archives.
One for you, and because it's that Declaration of Independence, that's what we're going to be depositing. That is a special deposit instrument. That's a non-negotiable instrument.
Yeah, we're going to treat it as a special deposit, and that would indicate it is non-negotiable.
Okay.
Special deposit or a trust deposit is non-negotiable.
And
it's private.
And since it's a non-negotiable instrument, they have to get an original copy. And so they get a copy, and the second one would be for us.
Well, we're going to keep... yeah, well, two is just copies, or not two originals, let's put from them. That, just in case we screw something up, we got another one.
Okay.
It's just kind of like a backup. But the definition of trust deposit on blacks, 4th edition blacks this time. Trust deposit, where money or property is deposited to be kept intact and not commingled with other funds or property of bank, and is to be returned in kind to the depositor, or devoted to a particular purpose, or requirement of the depositor, here's the kicker, or payment of particular debts or obligations of debtor, also called special deposit. So you can't make a particular debt or obligation payment unless it's made in special deposit, a.k.a. trust deposit.
Right. Now, back on the IRS...
No payments into the Treasury on the debt side, by the way. We didn't make them, and we didn't make any trust deposits. They're all under creditor.
Back on the IRS... Back on the IRS sending the presentment, if they're construing me as trustee, and I don't want to be the trustee, I want to be the beneficiary, so I'm not looking incompetent like I'm trying to do 2 things on the same trust. If I write them back and say, hey, fellas, I made a mistake, and I'm the beneficiary, not the trustee. And
well, I might want to play it the other way. I might want to claim that I am the beneficiary, because I've got the right to call a protective trust because all you other guys are bankrupt. And then under a Treasury directive hearing under 25-06, I'm going to submit my payment on the private side of that and tell them, hey, here's the payment to make you guys solvent, but you can't come at me and charge me because really, by law, under trust, discretionary trust, I withheld because you guys are bankrupt.
Yeah, well, that's what I was asking you earlier, because they're already construing me to be trustee.
Yes, right.
But I said, why don't I just write them back and say, okay, I agree, that this payment's due, but however, I'm withholding it because you guys are insolvent.
Right. There's 2 ways you could play this.
So either send me evidence that you're solvent, or send me evidence of how much you need to get solvent, and I'll issue private credit for that too.
Yeah, but now you're asking them to do something that, since you're the trustee, you didn't make the payment, and you're in breach of trust because you didn't make the payment. So you are presumed to be guilty and can't prove yourself innocent unless you show a record of a payment.
Or if I show a record of why I'm not making the payment because they're insolvent.
True, yeah, in chambers, yeah, in the private.
Which way would you do it if you had an IRS presentment? Would you write them back if they're already presuming you to be the trustee and say, hey, I agree, and just go ahead and issue them the private credit to take care of it? Or say, I agree with this payment, however, you're not solvent, so that's why I'm withholding it. Or
yeah, I might want to agree with them. That way, there's no controversy, and then do the DIB hearing with them, and then come in with the evidence why I didn't make the payment, and then, oh, by the way, here is a payment to make you guys solvent, and when you're solvent, then release the funds to me.
Would it be better to do it that way, or to write them back and reclaim the beneficiary title? Because are you, by going ahead and staying the trustee, are you looking incompetent, like you said earlier, because you're looking like a beneficiary on the card and a trustee on the 1040?
Yeah, but it might be that, I have to correct a lot of other stuff because I might have to do one with the commissioner and get my whole record, effectively disconnected.
Cut the head off the snake.
Mm-hmm. So I have a separate issue, this now thing we got, but the real problem is the whole thing, which is, it depends which way you think you could handle it, maybe the quickest or the easiest, but yet I would still lean back to getting the whole thing cleaned up, first. It would be probably the best way, but, I can't really answer that question for you.
Right. Okay, I'll let somebody else take a crack at you. Thanks.
Okay, anybody else have a question? Press *6, and don't forget to mute back out when you're done, so we can get in a lot back.
Hey, Christian, this is Eric.
Eric, how you doing?
Hey, great. Hey, couple of things. For one, the guy that was having trouble with his employer, I was with they getting that letter from the IRS and them just flipping over on him. What if he were to get a harmless agreement so they wouldn't be responsible for anything they did when he tried to claim his tax status?
Okay, you kind of like clicked out there when critical part. Could you kind of go over that again?
Yeah, I said, what if he were to give his employer a hold harmless agreement so they wouldn't be liable for whatever they did on his behalf to the IRS?
Yeah, where's the trust in that?
The employer's not going to be able to recognize the trust. I think that's part of the problem that he's having, but they're not doing it because of any. I think they're not doing it because of any harm that they might suffer. So at least if he releases them from liability, he might be able to achieve his goal.
I think you might have misconstrued him. I think he said he had success with the employer. The employer rolled over because the IRS came in with a letter, basically did what he said on the 8 bends. Is that caller out there? Could he come back on and maybe clarify that for this party? I think that was Keith was his name, I believe.
Well, the reason that I
say that the IRS basically made
can you hear me?
employee kneel to their wishes and to go against the employee. That's what I thought he was trying to say.
Okay, he's back on again.
Yeah, can you hear me?
Yes, go ahead, Keith.
Yeah, I hate using the terms employer and employee. I mean, that is, you look up the definition of those words. Employee means you're holding office. You're a government worker. That's how they commit fraud upon you. They give you the W-4, you fill it out, you're claiming yourself as a government worker. You're working. That's why they can withhold the federal tax from you. But anyway, the IRS letter indicated that the company I work for is not to change anything without a direct letter from them.
Oh, so they didn't do what you asked?
No, they didn't. They did not. Again, I said they rolled over. They followed what the IRS said to change my withholding status to single with 0 exemptions.
Okay, I see. I misconstrued that myself. I thought you had success.
Well, initially I guess I did it incorrectly. I upped my exemptions to reduce the withholding.
Yeah. Okay. I don't think identifying them would be the trick that would do it. I think you have to come back in and express the trust and do some corrections on the different trusts that are involved, just like what Rhonda was talking about with her, that the Social Security number is, you're the beneficiary on that one, and the IRS 1040 form, you're the trustee, and they're in conflict with one another.
I understand what the gentleman said about the hold harmless agreement, and I heard about, giving the company you work for, a bond for $500 million, all that stuff. But the long and short of it is the IRS letter indicated that the company does not change anything unless they have a direct letter back from the IRS.
Mm-hmm.
Now, the moron I have working on my payroll.
Well, there's where your problem at. They're telling you got to correct our information that's in our hands of the IRS, your individual master file.
Okay, that's what I need to find out how to do. Like I said, besides me sending affidavits and WAPENs and everything, the IRS trying to change that file.
Yeah, that's basically what we're talking to Rhonda about. We got to go back and correct that master file first with the commissioner before even her issue within the IRS is going to be solved.
I sent the commissioner, again, it goes back to that SEDM website, all kinds of affidavits that I'm not conducting a trade or business within the federal jurisdiction, blah, 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 all the way down the line. And it was just...
My question is, are they using those forms in trust, or are they just doing some more stuff under debtor creditor?
Don't know.
Yeah. See, we're sticking with trust and trust solely. I'm taking debtor creditor stuff and putting it on the shelf until we got trust established. And once I got trust established, I'm going to come in and do debtor creditor.
Hello, Christian.
Hey, this must be Dave. How are you doing, sir?
I'm doing great, sir. You know, I think it was a little bit confusing when you said you'd be the trustee on the Form 56, but you don't want to be the trustee on the 1040, so maybe you could delineate those.
Yeah, the trustee on the 1040's got me established. I signed up for trusteeship, but that's in conflict with the Social Security one. But, you know, it just depends how you understand it. You know, you can flip-flop this about any way that you want to make the picture puzzle, you know, come out the way you want it.
Well,
because my understanding is I can play this game both ways now.
Once you prove the trust, you mean?
Yes, any way that I want to. I can prove it being beneficiary, or I can prove it being trustee. Whichever way suits my purpose is the immediate issue.
Okay, what is your proof again?
Well, what the proof is that I have to create that proof. And then I have to understand, you know, okay, how am I creating the proof is dependent upon, you know, my knowledge of the four elements: intent, purpose, parties, and specific res, and one of the four methods of formation, and coming up with a record so that I can prove whatever standing that I choose, whatever hat I want to wear, to achieve whatever purpose I want that I can enforce.
So you're doing it by selective circumstances.
Yes, each individual one is based on how I'm going to see that could be the best way to play it out.
Okay. As long as you have the four elements and you meet all the criteria, you're right. There is a trust in existence and you can claim the grantor.
Yeah, like in one situation, it could be I might want to agree with them, say the IRS problem there, and go ahead and come back in and play the protective role in the private side and in chambers, and this is the reason why you can't count me guilty. And oh, by the way, I'll make you solve, and here's the payment. Or I could wait, and I could go back in and then correct the thing that's got me all jammed up in that court, in that situation, which is the fact that the trustee is on one document and the other Sesticate trust has got me as beneficiary and they're in conflict.
Well, speaking of those in-chamber events, you were mentioning that you don't want to bring in your evidence. You want to keep all the originals in the private. But you have to put public notice of them that they exist, at least.
Right.
In the public record.
That's how I'm going to get the evidence.
Yeah.
I pull out certified copies of the notification in the public. Now, that's something that they can...
So in lieu of the originals, you put in certified copies as the evidence? Is that what you said?
Well, my certified copies I can get, you know, out of a public record. You know, I get multiple certified copies. If I can get multiples, I can send them a certified because I got a certified for myself. And I can pull out more certified documents. If I had that...
Let me just make an example. Let's say you wanted to put a quitclaim deed in the public record, but you don't want to put the original in.
No, I don't want to put that original. I'm going to put a notice of that in.
Okay.
Pull that out certified, and I can pull out as many certified copies of that notice that I've recorded as I want. And I can send them a certified copy of that notice that I've recorded. And I can keep one certified copy.
So, really, though, the people just see this as a notice. They still don't have evidence of the actual quitclaim unless you show it to them.
In private.
And so you're only going to... Now, if you sent to the parties, let's say the mortgage company, you sent in a certified copy of the original quitclaim, that would suffice? You wouldn't be overplaying your hand?
Well, I have to give the other party, you know, notice of the documentation that we're talking about. So they had to have at least a set of copies at one time or another. I can't just, you know, send them a notice of something.
Right.
Because we got an agreement, we got a private agreement between me and, say, Mr. Bank. And I have to give them the documentation of whatever the original contract, so to speak, was. But everybody else is just going to get a notice because they don't need to know, because my private dealings with the bank is private. And that bank can't make it public, because if they attempt to make it public, I'm going to put a protective order on it. And they'll be in breach of the public side of the court.
Now, when you say the bank, are you talking about the bank's attorneys or the bank itself?
Well, the bank is the one I got the agreement with, but if the attorneys are representing the bank, they're just agents to the principal. Bank is the principal.
So are you just going to continue to communicate with the principal?
No, I could communicate Yeah, on some things, let's put it that way. I might want to communicate directly with the principal, but some of this stuff I might want to, I've got to put motions in, and the court requires that I serve notice on the attorneys.
Mm-hmm. Well, do you ever ask the attorneys to prove that they're actually eligible or authorized to represent the bank?
Yeah, you can ask them to prove up capacity or agency, yeah.
Now, if they have put that so-called ownership of the equity into a trust, doesn't that make it already negotiated?
Say that again, if I did what?
If they come back and say, we are the attorneys for this trust that holds your mortgage. Okay, in other words, your mortgage got sold into a trust. Deutsche Bank does that a lot. That would indicate that it's already been securitized, and securitization is illegal.
Well, let's say that securitization under 9-336 in UCC says that they commingled the funds. And if they commingled the funds, then they violated my special deposit I put into trust, and they violated the trust and breach of trust. Now they got big problems with me. They're made to claim of trust and prove the trust in order to be able to come back in and claim all that stuff.
But I don't want to take up much more on the call, but I want to get to the point where you're going to merge the two titles in the in Chambers, and it's just kind of fuzzy to me how the two titles merge together, and when they come together, you say it satisfies the obligation.
Well, I got two options. I can compel the trustee to do his duty, which is disperse the funds, or I can merge the titles in the trustee and terminate the trust, which he must disperse the funds then. Either way, I achieve the same results.
Now, when he disperses these funds, where do these funds come from?
They came from your signature, my special deposit. I get the incoming deposit back.
What about all the payments you made?
Well, those are the proceeds generated off the original deposit, which was the interest contract.
So do you submit some form that itemizes all that?
Well, see, we're not making up, according to banking, we're not making up certificates of deposits of our deposits and specifying interest on there. They do it. How come we're not doing it? See, under debtor-creditor, they're getting to create all the records that they need to prove debtor-creditor, but you're not creating any kind of records to prove trust. And they've got a history of everything they're duping you into signing because you didn't know or understand, creating all these records to prove that it's under debtor-creditor. Now you got to start creating records under trust so you can countermand their records under debtor-creditor.
And of course you're going to show us how to do this step by step in the workshop.
I've been talking about the same thing.
Yeah, but you have to go listen to like 40 hours of stuff to pull, 5 minutes out here and 3 minutes out over there. It's for you probably don't realize how much you know compared to us.
Yeah, because I realized that I thought we were 3 steps ahead, and when I talk to people, I find out we're in step 1. They don't understand moving titles platform. They don't know how to move. They don't know how to claim and move titles. And they don't even know how to use a notary presentment. So how can we talk about NTT and merging titles when you guys don't all understand how to use notaries and create records, let alone how to claim and move titles, let alone talk about merging titles in trust?
One of our problems, Christian, is the application. It's like a football team. They'll run the same play in practice 100 times.
Yeah, you're right.
Why? Because repetition, you got to repeat this stuff. You can't just run through it. Hey, I got it.
Oh, well, believe me, I've been repeating.
I know, but we got to not only repeat it, we got to...
We're all slow learners.
No. Some of us actually have to do it. Some people can get it just by hearing about it.
In the workshop, we'll have better access because I've got access to a whiteboard. We can draw diagrams. We can go through some examples, and we're a little more in depth and concentrate up. But people are going to join the workshop. Don't expect to join this workshop and said, we're going to put some documents and solve your NTT problem with NTT. Right off the bat in 2 weeks. It ain't going to happen.
No, you said it was going to be 5 weeks at 4 hours a week.
Yeah, it's going to be 5 weeks, but, don't expect to be able to go ahead and attend this workshop, and 2 weeks later you're going to be king of the hill. First we got to explain how to use
show on the road,
how to create a record, And then we can talk about how to how to claim titles, create titles, and how to move titles. And then we can get to trust stuff, because really one is built upon the other. And really, this is all basic government that we should have been taught in school, but hey, they didn't teach us this in school. I wonder why.
I think we know. I appreciate your time. Thank you so much. And have a great evening.
I realize there's a sticking point. You know, we get many people on the calls that are new, and we go over the same information. But you know, that's kind of good in a way, because we keep going over the same thing, and you know. But don't expect to listen to one download and think that you have it all, because it takes many downloads to get it all put together. And I've been talking over a year and a half on how to move titles and how to claim.
Well, I don't know many people have been listening a year and a half. I just met you in July.
Yeah.
You kind of shifted gears about that time to trust. And
right. Yeah.
So I appreciate all you did. But you're right. One download, believe me, not even close.
Yeah.
All right. That's all I had.
Hey, Christian.
Yes, who's this?
This is Cynthia again.
Hi.
You mentioned that those funds were commingled and need to be returned, but as a trust, as the beneficiary, in what denomination would those funds be returned? Because
you same thing in, you get the same thing back out. And if it's been endorsed or modified in any way, they've commingled. So if you have an original note that you signed at mortgage closing that you put into special deposit, you should get the original thing back out without any marks or alterations or anything on it. Now, do you think they can do that?
No, they can't.
Right. So that means that they won't produce the document, because if they do, they just pled guilty to commingling. So also, securitization is proof that they commingled. Do you realize how powerful that is? Because now you got them in breach of trust. And I don't care which way they go, whether they prove it up or whether they don't prove it up, you got them.
Okay, I think I have to sit and go over that in my head, how that would work out. If your position, in a sense, has changed, I can't see what you could do with that document now that your position has changed.
Well, if I ask for the document back because I special deposited, they can't give me the document back. Well, now I bring up causes of action against them on breaches of conversion, breach of trust and conversion.
Well, how far can the cause of action go if you're doing all of this notating, if you will, in chambers privately? And then
well, no, the causes of actions are not in the chambers. The causes of action are on the public side of the court.
Yeah, I know that. That's what I'm saying. But all this information that you're bringing up about the commingling, that's done in chambers, right?
Yes and no. I may want to do discovery and force them into admissions and interrogatories that proves that they, can't get the deposit back. And I'm going to take that evidence that I gather on the public side of the court and use that in chambers and bring in all this hammer stuff and really get them.
So it's almost as if you're practically playing a chess game.
Yeah, I'm playing both sides because I know how to master both sides. And I play both sides simultaneously.
Another thing is operating this, you would operate your information or beneficiary position. I would operate my beneficiary position. And if we come to the point where we're collapsing the trust and eliminating or terminating their position, shouldn't that be done as a whole as opposed to separate parties?
Well, what we're confusing is we have many trusts we're talking about. You're probably talking about not knowing it, maybe three different trusts here.
Oh.
A case is a trust. Now that case is within another trust, which is the Social Security account. So it's a trust within a trust.
I see. Okay. Yeah.
So we have to distinguish, hey, there are many trusts going on that we're doing, and they're all like within each other because they're all trying to gain access to that one Cesta K trust to get access to the funds.
Okay. Now one of the elements of a trust is the intent.
Intent, yep. Which is the grantor's intent.
The grantor's intent. Now the grantor, I guess the question would be, did I have knowledge that I was had the intention, even though I'm the grantor, that I had knowledge that I was intending to create a trust through my signature? In other words, that intent, shouldn't it be knowledgeable?
Well, were you on the last Saturday show?
I'm thinking I am. Of course, all of them are muddled now because I'm going back and forth, putting some pieces together.
Saturday, I went over intent.
Okay.
Really big time.
Okay.
And I went into the sentier, and I went into knowledge and understanding, and went through all the intent.
Okay.
Because it's being construed two different ways. The intent is different from the public intent. Because they're getting you that you don't have to know or understand in the public that a trust is being formed. Mm-hmm. Because your intent is really demonstrated by the act or deed that is confirmed by a record. And that proves your intent, whether you knew it or not.
I see.
But on the private side, you can't complete something unless you really knew or understood. In other words, you have to be sentier. So sentier means that you have to know or understand in order to do an act. But on the public, it's different. It's the mere opposite. And that's how they're hypothecating us into slavery on the public side.
Okay. Okay, and that actually makes sense. So I must not have heard the Saturday call. So I go back and go over that. Thanks, Christian. Appreciate it.
Yeah, if you don't have it, send me a request. I got the download link. So.
Okay. Okay. Thank you.
But hey, Christian, let me finish up here with her for something. I'm talking about causes of action that you can do, and it starts out. We had a fraudulent transfer on that special deposit, and we have unclean hands that's generated from that also, and we have unjust enrichment, and we have conversion, along with fraud, which is going to be also misrepresentation and unconscionable acts or practices against the consumers, which is unfair business practices. And then the big one, we're going to come in with antitrust, because really they have a monopoly because they're impeding commerce, because you're disadvantaged because you don't have the skills and the knowledge that they...
Oh, did I get dropped?
Pardon? So we have antitrust as a causes of action also. That's the big hammer right there, the antitrust. And all these causes of action, they're going to be brought into the public side of the court and making accusations against Mr. Bank that they're doing all these things. They're in big trouble. So, anybody else have a question?
Yeah, I do. Can you hear me?
Yes, go ahead.
Well, I've been frankly trying to ask questions all night, and for whatever reason, the call would never let me unmute. I finally had to kill the call and call back up again. You were talking earlier. You were talking about the. I hope I can remember now. It's been so long since you were stated something about you referenced 332, but I think maybe you meant a different section with regard to making the correction.
Yeah, the mistake. Mm-hmm.
Yeah, what section is that? Because it can't be 332. That's fraud on page 93.
Oh, no, this is out of the restatement on the law and trust, the second.
Oh, this was not out of Gilbert's.
No, this was not out of Gilbert's, no.
Okay, that's why I couldn't find it. And then I had a question that I wanted to ask about. We've been talking a little bit about the codicil, a label on the 1040. And so I was trying to get a little better understanding about what type of a trust maybe was created when we did our first 1040. The language on page 100 on section C, creation of testamentary trust, suggests that testamentaries are only about wills. But on 101, when you look under the creation of trust, the little box there, it says that by settler under testamentary trust, by settler's will, the essential elements of the trust, being res, beneficiaries, and purpose, must be ascertainable from will or codicil.
Mm-hmm.
So I'm wondering what actual type of a trust have we created whenever we did the codicil label on the 1040 form? Do you think it's a testamentary trust in that the straw person is not really alive? Folks like Winston have suggested that the straw person is a decedent. What are your thoughts on that?
Yes, he dies yearly.
So they suggest on section 1 on 100 here, testamentary trust is one created at the will of a decedent.
Yeah, but see, you're doing excessive trust. You're making yourself trustee by making yourself out to pay debt and having an income, and you continually, year to year, appoint yourself trustee. which is in conflict with your Social Security number that you're the beneficiary. So obviously you're incompetent, and we're all incompetent until we correct this mess. And then they won't allow us to do the set-offs because we are incompetent. And not only we're bankrupt, we can't make the payments because we haven't paid the debt. We're insolvent.
So we're restating ourselves as trustee by filing 1040s each year, or?
Yeah, we're screwing ourselves up by filing 1040s each year, yeah. But once you made out a 1040, you've appointed yourself trustee, and they've got you from that point on.
Well, I remember there was a push a few years back by some folks, maybe Rice McLeod and some others, about doing 1041s, and then apparently a lot of folks who were doing 1041s got in trouble for doing them. Was that because they had not expressed the type of trust that they were involved in prior to having filed those forms?
Correct. You got to express those. They had claimed that there is a trust, and then prove the trust first before you got the right to claim that you're grantor or any other party on the trust. But if you've established who you are to begin with, and you come in and you don't prove that you're otherwise, then you've got conflicting information, and which one do you think they're going to take? The first one in is going to be the last one out. They're going to get you under FIFO.
So it wouldn't. If someone had expressed the trust properly, they might well be able to get away with filing a 1041 rather than a 1040. Is that what you're suggesting?
Yeah, but expressing the trust means that you prove it also, that you have the records to determine that you are, say, grantor and beneficiary.
So these folks that just went out and just started filing 1040s, they had already set up a situation where they had...
Yeah, they just raised an NOI claim without a substantiated, followed up by an SOI statement with material facts to prove their NOI, and it timed out.
Their previous filings of 1040s had them making a declaration of being the trustee of that particular type of an arrangement. When they came back with a 1041...
yeah, do you know if they submitted any W-8s with that?
I'm assuming no. We're talking a few years back. Some other callers out here might know more about it, but I remember that there was at one point a lot of talk about people doing 1041s, and I think there was quite a large number of folks that actually did them, and apparently a lot of folks had pretty severe problems after having done that.
Yeah, because they don't want you going the trust route unless you're going to do it right, because you're knocking on home plate.
Right. I don't mean to create a conversation about 1040s, 1041s, but since we've been talking about how the 1040 itself has a label and is a codicil, that seems to be an important element as to the declaration. And there's been some discussion about folks not filing 1040s. As a matter of fact, I had an acquaintance who didn't file one ever.
Yeah, but did they revoke the 1040s for the reason that they want to switch it around? They want to modify the trust that they formed. So once you find 1040 and formed a trust, that trust is still in existence until the grantor comes in and modifies it or terminates it, or the trust purpose is fulfilled.
Right. Okay. All right, I don't have any other questions right now. Thanks, man.
Okay.
Thanks, Christian.
Right. Anybody else have a question?
Moving titles, is it?
Moving titles.
I get a bounce back. Moving titles at hushmail.com.
That means the box is full.
Thank you.
Keep trying. Let me get a chance to, clear it out, but don't give up,
Yeah, maybe you'd clue me in. I need information more how to plug into the calls and the workshop.
Well, if you've never sent me an email before, I got to keep on trying, because when you send me an email with moving titles, I can put you on the list through that email. And once you're on the list, and I got you on the email list, you'll start getting, the information of when the next shows and some updates and the announcements and whatever else.
Excellent. Christian?
Yeah. Mm-hmm.
It's Rhonda again. On the creating the record on the UCC, non-UCC filing, we're just creating a record of the collateral that we're claiming, the title or whatever it might be.
Right, we're not using UCC to do a debtor-creditor filing, no.
Right, to do a debtor-creditor filing. So when you're doing a UCC, non-UCC filing, does there have to be a debtor in there?
The is determined by the nomenclature down at the bottom there, where it says, like Baylor Bailey, you check that block, and all those words up above then change to Baylor Bailey, not secured party creditor and debtor. So when you check that non-UCC filing, all that stuff is different.
Okay, because I know somebody that said that she called and talked to the Secretary of her state, because I was telling her about, we're not using the UCC as a UCC filing. It's just, and that's a non-UCC filing just to create a record. And she called and asked the Secretary of State of her state, and they told her that no, even checking a non-UCC filing box, that something had to be in there. Does that sound right to you?
Yeah, you got to have something in those blocks. Yeah, you can't leave those blocks blank.
Oh, like the debtor block?
Yeah, you got to fill in parties in there. Yeah, so you got to put some entities in there.
Okay, so if you're just claiming collateral or claiming a title.
Yeah, but who's collateral? You're identifying whose collateral it is.
It's your collateral.
Yeah, so I got to put down who I am.
Okay, but if you're just claiming collateral and it's my collateral, okay, I got no problem putting down who I am. But like in the debtor's box, what would you?
Who's the party I'm going to send it to? Put them in there too.
Okay, gotcha.
Okay, who's next? Press *6.
Hi, Christian. This is Dean.
Hi, how are you?
Hi, I'm fine. As far as I heard you talking about sending an email to you there to get on your list, and is that how we get to where the downloads are too?
Yeah, because if you don't have a list of the links requested from me from that email address, movingtitles@hushmail.com, and then I'll send you the list with the links on it.
Okay, I'll do that. And two questions. One that went back to when they were talking about a speeding ticket, an example of having a speeding ticket, and that you would plead guilty to the facts but not the charges. Would the only facts in the case be that there's a monetary amount, or what exactly would the facts be?
Well, whatever they put on the implementation for the straw man, that's the facts. All the other stuff is all lies.
When you say whatever they put on the implementation of the straw man, how does that translate into?
On the ticket, all that information on there is really a straw man. It's really not me. But then you came and you signed it, and they formed a trust there because they're doing commerce, but it's a contract. But there's really no contract because we don't have any money to complete a contract. So you were forming a trust right there.
In Washington, they don't even require any signature. They don't ask for a signature anymore.
Yeah. Well, they're switching things around because they're claiming now that we got your signature already. By accommodation signature rights, we can put your name on anything we want.
By accommodation?
Yeah.
Also, what, when you're talking about 1099 OID and what that does in effect, with these relationships, what happens, and the BC bond. What happens if you just A for V the BC but don't do a BC bond?
Okay, except for value is debtor-creditor, and we don't do except for value and trust.
Okay, I was just trying to understand what would be happening.
Okay, what we do is except for value, and that is on page, 127. It's sections 441 that starts, and in particular section 442 in the Gilbert's book.
Okay.
And this is talking about alienability of beneficiary's interest. So it's a lien against the beneficiary's interest, and that's the lien is the hot potato by the creditor that's trying to foreclose or a charge by operation of law or something. But then 441 is the right to transfer in general, and then the rationale, and then under B, under section 442, it says transferee's rights. So here's the except for value, return for value, liken the two, but this is trust now. So a beneficiary can assign only such interest in the trust as she has. The transfer is not a transfer of the trust res itself, but only of an equitable interest therein. Whatever conditions or limitations, now the limitations, that would be the lien they're trying to put on, attached to the beneficiary's interest prior to the assignment apply against the assignee. So I can, after there was a lien put on this interest, if I assign it to somebody, then also the assignment goes with it, or the lien goes with it. So I've returned it to the other party by an assignment, and it actually achieves the same thing except for value, return for value does. Flips it back to them.
And what lien would that be?
Anybody who's giving you an offer is actually trying to get you in a lien situation under debtor creditor and gain access to the funds in the trust.
Okay.
So any charge or indictment or offer that comes to you in the mail under 3-115 is really an incomplete instrument looking for a signature. And once they get your signature on there, since you didn't express it to be a trust, they're going to construe it to be debtor creditor, and now they got you.
I'm fairly new to the trust aspect, and so I'm trying to wrap my mind around this.
You have the book?
No, I don't. I just. This is the first call I've been on.
Okay, you have to get the book.
Okay.
It's only like $30. Gilbert's Law Summaries. They make different ones on trusts and tort claims and contracts, but the one you want is trusts.
And the 2008.
2008 version, right. You can go like your law library, might have a bookstore, and you can probably pick it right off the shelf. Otherwise, you might have to go to Barnes & Noble and order it. But if you order it off the Internet, make sure you get the right version, which is 2008, or else they may sell you an older version.
Right, okay. Well, I think that's it for now.